In this session, we will see about the agency in Contract Act. Contract Act section 182 defines the agency. Agent is a person employed to do any act for another or represent another in dealings with third party. There are two things. One is to do any act for another, doing something for another. Second, representing another person. For example, there is a seller, he has to deliver it to the buyer. He cannot go personally, so he will call a transport operator, hand over the goods and instruct him to deliver to the buyer. Now the transport operator is the agent and the seller is the principal. He is doing something on behalf of this seller. Actually, he has to deliver it. Now this person is going to deliver on behalf of the seller. This first. Second is representing a person in dealings with third person. For example, if there is a seller of land, he may appoint somebody, you find out some prospective buyers and negotiate with them, then you come to me. Now this person is representing the owner in dealings with the prospective buyers. Then we will see what are the essentials of the agency agreement. Agency agreement section 183 says, any person who is of age of majority according to the law to which he is subject and who is of sound mind may employ an agent. So the principal should be competent to contract. He should be of sound mind. He should be of major. A minor cannot appoint a principal. Any agreement made by the person appointing an agent, if a minor appoints an agent, the agreement is void ab initio. It cannot be ratified. But one thing, in the case of a guardian, he can appoint an agent on behalf of the minor. Guardian has the power to appoint the agent on behalf of the minor. This is section 183. Now, who can be an agent? Section 184 deals with who can be an agent. The wording says, as between the principal and third person, any person may become an agent. So, there is no qualification. Even a minor can be an agent according to section 184. Only the principal, minor cannot be a principal, but minor can act as an agent. For example, in the landowner, he may appoint a person who is of 17 years old. This boy may be appointed as agent in dealings with the third party. He may contact the prospective buyers and he may finalize the deal. Why this reason? Because the agency has no connection. The agreement is between the principal, the landowner and the persons who are buying. Only he is facilitating the transaction. So the act says he need not be a major, even a minor can do that. But one condition it is there, the minor will not be liable to the principal for his act. The principal cannot make the minor personally liable for his act. In the same case, if the 17 years boy has done some wrong and the principal has incurred loss, then he cannot claim it. But in the same case, if he is a major and if he has done something wrong and the principal has incurred loss, then he can claim from the minor. Then the third is regarding consideration. Section 185 says, no consideration is necessary to create an agent. As a general rule, consideration is necessary. Without consideration, the contract is not valid. But this is an exception to that general rule. The Act specifically says, no consideration is necessary to create an agency. Now we will see what are the kinds of agency. There are three types of agents. One is factor. Factor means the person is given the possession of the goods and he acts as an agent. For example, there may be a person who is a wholesale dealer. The manufacturer will place everything in his shop. This person will sell and then account it to the other person. This is factor. Next is a broker. Now this person only negotiates. For example, the same land broker case, the land person who is appointed as a broker, he will negotiate with the third person and he will intimate this is the final price I have negotiated for you. This is a broker. Next is a Del Trader agent. Del Trader agent is a person who promises that there will not be any bad debts. I will take care of that. This person is selling goods on credit, but the principal will not incur any loss on account of bad debts, because this person, like an insurance, he assures that there will not be any bad debts. But for that service, he charges something extra. Extra commission will be charged by the Del Trader as Del Trader commission. Now we will see how the agency agreement is created. Agency agreement can be created by agency agreement may be expressed, that is by writing a letter or by oral. By express, agency may be created. Next one is by implied. By the contact of the person, the agency relationship is established. In one case, Smith versus Mose, mother purchased a car and engaged his son as a driver, and he was driving the car. Wife of the son, the car met with an accident, wife of the son injured in the accident. Wife of the son's wife got injured. The wife claimed damages from Smith, who is the owner of the car. She contended that there is an implied relationship, that person acted as an agent for you, and he won the case. It was treated as an implied agency. Another thing is estoppel. When there is an estoppel, the person will be made liable for the acts of the agent. There is no principal and agency relationship, but still the person will be made liable for the acts of the agent. What is a estoppel? Estoppel means by his own contact he makes others to believe that he is the agent. Actually he is not an agent, or it is not within his scope of agency agreement, but the principal by his own contact makes the others to believe that he is the agent, and on that basis the others transact with the agent, business with the agent, and incurs any loss, then the principal will be liable. The act says, if he has by his words or contact induced such a third person to believe that such acts are within the scope of agent's authority, then the person will be liable. Then we will move on to the next one, that is agency between the husband and wife. It is implied agency, that wife has a implied agency, implied authority from the agent, from the husband to act as an agent. For example, if the husband has not provided any necessaries, then the wife can purchase it from the nearby shop. There is an implied agency. For that, some conditions are there. They should stay together. The husband should not have provided the necessary. The goods should be of necessary, not luxury things. But on the contrary, that husband cannot claim that I have an implied agency. I am the implied agency of the husband, wife. Wife can be the implied agent of the husband, but husband cannot be implied agent of the wife. Next, agency by necessity. Because of some necessity, agency relationship is there. For example, somebody sent some goods, it is going in the sea, it will not reach the destination, may get perished before that, then the ship captain will sell it. This case, Sims and Company versus Midland Railway Company. Butter was dispatched by ship. It was going to be perished, so before the destination, the ship captain sold it. So it was treated as a agency for necessity. Another case, Great Northern Railway Company versus Swaffield. In this case, horses were sent by train, but the other person did not take delivery of the horse. What the railway company did, they made a place for that, and feeding, all the expenses they incurred. It was held that it is a agency by necessity. But for that there are some conditions. It should be that person should be inability to communicate should be proved. The agent should not have the facility of contacting the principal. For example, in that ship case, he could not contact the owner because he is on the high sea. He could not contact the owner before that the sale is made. He could not contact. The first one is there should be no communication between the other person. He should take the responsibility on his own because of the urgency in the matter. Second is act should be reasonably necessary. If it is not necessary, you cannot presume that there is an agency by necessity. One case is there, Munro versus Wilmot. In this case, one person kept something in a place and he did not turn up. What this person did, he sent notices that was not acknowledged by the other person. He has sold the article, but it was held that it was not necessary. Another case is also there, Such versus Milkos. The furniture were kept in a place, in a friend's place, but she did not turn up. Notices were sent, the furniture were sold. Here also the court held that it is not because of necessity. There is no agency by necessity. Another one is bona fide in the interest of the party concerned. It should be a bona fide. He should assume the agency position for only for bona fide reasons. This is in the next session we will see duties of the agent. What is agency? Is agent is to do an act or represent something. Agent can be a minor, but a principal cannot be a minor. No consideration is required. Agency may be created by express or by implied or by necessity. In the next session we will see duties of an agent.